be too concerned about that. Our first case this morning is Allen versus Wells Fargo.
Your Honor, Randall Reeder, attorney for the appellant, who's in the audience, Benjamin Allen, and opposing counsel is Michelle Cavallero.
Okay.
This case is one that is a little bit convoluted factually and
A little?
So I help, if I may, start off with some of the time deadlines and briefly.
Have you shown this to
Oh, I'm sorry.
counsel?
I'm sorry. It's just time.
Are you okay that he's using this?
I'm fine with it, Your Honor.
Okay, all right, thank you.
Actually, Mr. Reeder, can I,
Yeah.
before we get into the merits of this, and in reviewing this in great detail, one of the issues that I'm concerned with, whether or not there's a final appealable order in this case. Because if you look at the whole, before we get into who, what, where with the equitable subrogation and whether or not the interest was appropriate and all of that, there's been some talk below among lawyers that one of the counts was going to be dismissed, and then on a summary judgment, it was not. It says, well, we're not going to go forward with it. I have looked at this entire record to see if there's any order of dismissal. There is none. And so what caused me concern is this. It's a summary final. It's styled as a final summary judgment, but it's actually not, because there's other pending counts. So just because we can't get into that if we don't have the authority, if we don't have the jurisdiction to proceed. So help me out with that.
And my response to that is,
Yes, sir.
that it was pretty much agreed, because the first proposal that was sent to the judge to sign, that was the issue that came up, that it was being,
And you're
not...
right, and there's an
so
agreement by everyone that they're proceeding with that, but an agreement is not sufficient. There has to be an actual dismissal order in the file. So anything in the record that would indicate that the other counts have been dismissed, so this is the only thing that we're proceeding on.
And my response to that would be, if it's, and I have the same thought about that, Your Honor, and my reply basically is that it is in an order that is robbing him of possession, and that would be it. So I would request then that the court treat this as an appeal of an interlocutory order that deals with. So the court does have jurisdiction, in my opinion, because this is critical in terms of whether or not he has the right to be in possession of the house. That's why it's so important that we get a decision on that issue. And if you don't, if you believe that it's not finalized, although it has the language and it was intended to be finalized, but that is one of the problems I was having, is that there were left open certain issues, because I did raise them.
Okay, I just wanted to bring that out, because I'm concerned with the count one, because I know there's been talk among the parties, count one will be dismissed, will be dismissed, will be dismissed. There's nothing to indicate to that, but that's a concern. I'll let you go on with your substantive argument, but I just want to alert both sides. At least for me, that's just kind of a concern as to whether or not we can proceed, whether or not this is an appealable. I guess the best way, whether or not this is an appealable final order, or whether or not it's a non-appealable, non-final order. That's just kind of a concern.
Well, I don't think there's any question that it's an appealable non-final order, or because that rule specifically applies to judgments of possession. That's how mortgage foreclosure cases are all the time, even though there's a lot of issues kind of going on. The foreclosure judgment itself is appealable, because it's putting up the property for sale and depriving the person of the right of possession. With respect to that, and that focuses on the main issue here, is that there is absolutely no evidence, none whatsoever, to support any of the accounts, one or two or anything. Briefly, you have the facts are, Mr. Allen moves in onto the property, which is owned by his mother. Unbeknownst to him, she gets what's called the Conti mortgage. Things happen in October pretty closely. October 19th, she quitclaims half the interest, makes him half owner. 7 days later, there's actual closing on the mortgage. So they have constructive knowledge of the situation. So they give a mortgage. My argument is their mortgage is limited to her half. Real estate principles, issues, cut and dry, and you can't argue with what's recorded. So that's why there's no reason why we need to have testimony, evidence, or anything else. That's just a given. An assignment to MERS. Default is not until about 2007, and then the litigation starts.
Sir, have you shown any of these?
Yep. Okay.
And you're fine?
I'm fine with that.
Okay, thank you. Do you have any more?
No.
Okay, thank you.
Original complaint filed in February. The first final judgment that was entered October. There was a bankruptcy that stayed everything until it was dismissed. A second sale scheduled. That's when I was retained, filed a motion to vacate because on its face.
And just to save you time, Mr., we have all that information here. Let's cut through the chase. My question to you is, factually, didn't Ms. Sullivan transfer half of her interest in the property to her son shortly before she entered the mortgage?
Right.
And as if she owned the whole entire property, correct? All right. And there's no question, at least for the facts in this case, that Accredited, who's the lender on the second mortgage, satisfied the previous Conti mortgage in order to protect its own interest. And because I know you kept saying about as a volunteer, but not as a volunteer, and therefore under the law it stood in the same shoes as the lender. You agree with that?
No, it voluntarily, they paid it off because all the cases that they're relying on in terms of equitable subrogation, the courts have allowed it in situations where they were protecting their interest because there was a foreclosure already in place. There was no foreclosure in place. There was no need. She was just simply refinancing.
Why would that be a turning point analytically as to whether or not equitable subrogation is an appropriate remedy in this case? I mean, I hear you making the point. I'm just scratching my head as to why would it matter whether they took out whether they satisfied a prior debt in order to take the place of and collect on that debt that they then took over, or whether there's a pending foreclosure and they need to do that in order to better secure their interest. Why does that distinction matter at all?
Well, my argument, my response to that is that under both situations, Accredited isn't entitled to subrogation. Whether or not it paid the debt or it paid off the debt. Okay?
Yes.
Accredited did. That's a factual thing. The debt was satisfied. That's real estate law. Satisfied. For them to come back now and say, oh, we want to foreclose on a mortgage that's been satisfied is just, preposterous. To put it bluntly, I'm sorry.
But the case law says otherwise, Mr. Reeder. There's quite a few, and I think what Judge Lucas is trying to say, what is it about the case law? What is it? Do you have any case that indicates that under the facts of this case, that all of the other cases are distinguishable? All the other cases are wrongly decided. That's what I'm trying to
I think the
understand.
case that I cited in my brief is the main one, and that is the, get the pronunciation of it right here. The Rosansky v. Wells Fargo case, which I reference and describe in detail. That's I think, my strongest case law supporting my position, because it goes on and analyzes it and states why Fishbein isn't applicable, why Tribeca is distinguishable. The concept here is that for like an equitable lien for a company to have it, one, they have to have a promissory note, which they don't. There's no evidence that there's a promissory note anywhere. Okay? There's no evidence that
Actually, I just pulled the Rosansky case, Mr. Reader, because that was not my, and weren't the facts in Rosansky a little bit different? Because in that case, there was, it said there was no showing that Rosansky was in default on his mortgage at the time. And the court basically ruled because there was no showing that Rosansky was in default on his mortgage, the trial court erred in ordering the foreclosure of the equitable lien. That's a bit different from our case here.
yes, it is.
All right.
But there was no default. My analysis of that is they were talking because of the timing of that particular claim, because the foreclosure was happening immediately after the situation occurred, as opposed to here we had a default that happened years and years later, and that was the main part of showing this, is that the default's way up here.
Why does that matter?
Number one.
I mean, why does it matter if the default was 7 years later or 7 days later? What does it matter? For purposes of whether or not an equitable lien can attach.
So quite a bit complicated to explain that, Jan, but you have to look at all the facts and circumstances of any particular situation when we're talking about court of equity, and that's what we're here on, as far as a specific law, which, specific dates matter, okay? As a matter of equitable, it may or may not, depending on all the facts and circumstances of each particular situation. And that's what I'm trying to get across here. You look at all the facts and circumstances and all the dates as a matter of equity. And it doesn't matter, it's not a matter of 1 day or 7 days or 10 days. There's not a litmus test because it's not a legal issue in terms of with the time element to it. They brought 2 counts. One was the legal count, and they ended up dropping that because you could look on it and it had absolutely no basis from a legal basis because they didn't have any of the documents. I'm sorry, I thought it was going on.
Okay, that's
And
2 strikes.
So
You brought exhibits without asking permission, and you left your phone on.
I actually, Your Honor, it turned on, it rang, but I did
It's okay, just go
hit
ahead with your
I
argument.
hit the off
Just
button,
be very
is all I'm
careful
saying.
going forward.
I will. So I got a little distracted, I apologize. I'm sorry, what was the question, if I, a concern?
You weren't responding to a question, I believe you were just
Discussing
discussing
the legal issues.
the
that
equitable
we're talking
aspects.
about the actual assignments of mortgages. Okay? And that's what I want to get to, because that's the whole thing that they're relying on are the assignments of mortgages. And the assignments of mortgages themselves are facially invalid. You have the first assignment, which is here, which was taken right away. You have the other assignments happening in this period of time when there's no activity, of them in 2013, none of the assignments of mortgages say anything about transferring the debt. The case law is very, very clear that you can't foreclose on a mortgage or unless the debt, you've got to foreclose on the debt. So those documents themselves, there's nothing in the recorded, any of the evidence that they presented at trial to show that there has been any assignment of the debt in any form or whatever. They didn't produce the original promissory note. The first complaint said it was an affidavit to the last note.
I think what your friend would probably point out is, you know, that's why we're relying upon an equitable lien theory.
And two aspects of the equitable lien is my response to that was first, accredited didn't have the right to do it. And even if it did, the backup point is, how is that right ever transferred to Condor? Because somehow you have to step in the shoes, be subrogated. And there's no relationship, there's no direct relationship between Condor and accredited. There are all these intervening companies mentioned in assignments of mortgages, which are meaningless because there's no debt associated with the transfer of them. And the main thing, and Judge Little honed in on this at the hearing, when they're asking for equity, well, the equity is how much are you out of money? And
Mr.
there's
Reeder,
no evidence
if
at
you,
all.
I'm sorry to interrupt, but if you'd like to save a little bit of time for rebuttal, you've got 4 minutes left.
I'll save all 4 minutes.
Okay. All right, thank you.
Good morning. Michelle Cavallaro with Fidelity National Law Group, and I represent Condor Capital Corporation in this case.
And Ms. Kevlar, help me out with the jurisdiction aspect, because that kind of was a bit troubling before we get into the substance of it. Because there was no question in the whole transcript that both parties agreed, oh, we'll do that, we're not going to proceed, and then there's never been an order, or perhaps it's in the file that I somehow missed it, that it shows the finality of it, and I'm concerned about whether or not we could proceed, because I know Mr. Reeder is indicating possession. Well, when you think about it, this is an appeal from a non-final, basically summary judgment. Just my concern about that. Help me with that.
I will try, Your Honor. I will say, as Your Honor already pointed out, there were several concessions made. We're going to not proceed on count 1, the mortgage foreclosure. I believe Your Honor is right in terms of the record. I don't believe there is anything in the record actually dismissing count 1, the mortgage foreclosure. I don't want to misrepresent a fact to this court and tell you with certainty that there is a dismissal of that down the road. I believe there is, but it's not part of the record. And if that's the case, I believe there's still time we can supplement the record with that, because it's clearly not part of the record before any of you today. And that is a mistake.
Okay, thank you.
In terms of the rest of the case, which is really the equitable subrogation lien, I see this as 2 separate but related issues. One, could my client impose an equitable subrogation lien against this property? And 2, could my client foreclose the equitable subrogation lien, which is where the Rosansky case comes in. I think in terms of the first issue, whether or not my client could impose the equitable subrogation lien, I would rest on what we talked about in our brief.
One thing
Unless
about this
there was a
that
question.
kind of just, this looks like a title search goof, right? I mean, that somebody encumbered or transferred part of their interest 7 days before closing, nobody updated the title search, and the lender went on and issued the mortgage as if nothing happened. I know what the 4th District said on Bonk in the Riverside Bank case, that equity equitable subrogation can even relieve negligence. I don't know that this court has ever held that. Why should, why should equity intervene to relieve what is basically negligence in doing a title search for which you have title insurance, that if it doesn't clear the lien, or doesn't clear the problem, then it'll pay the difference on the mortgage? Why should equity intervene to fix that?
Well, I think I would say a higher authority than the fourth TCA, or even the third, would be the Florida Supreme Court's decision in the Fishbein case. And in that case, the Florida Supreme Court did say at one point, while discussing the facts of the case, that the bank was clearly negligent in allowing Mr. Fishbein to just go and get his soon-to-be ex-wife's signature on the mortgage documents. They didn't even have her sign the mortgage documents in front of them. That was clearly negligent.
But there's a little bit of an element of fraud there, which I get why equity intervenes in that case, right? And maybe there's record evidence that there was a little, something that shouldn't have happened in this transfer of the half interest. I don't know. I didn't see it if there was, but I'm not sure it's exactly the same. This to me looks just more like a goof going to closing. Nobody, checked up on the state of the title or the O&Es or whatever.
Perhaps, Your Honor, until you look at the fact that Ms. Sullivan in this case did knowingly enter into a mortgage knowing that she had just transferred half of her interest in the property to her son.
Did that get developed, though, in the record below, that, hey, you knew you did this and you didn't tell us, you didn't disclose it? In other words, did it get developed that maybe there was a little bit of duping going on in this case? Did that get developed in the record?
It did to an extent, Your Honor, but I will say not completely, because Ms. Sullivan passed away while the case was pending. So there's no deposition of Ms. Sullivan where she admits that.
No interrogatory responses from her and nothing?
She was deceased by then, Your Honor.
By that point?
Yes. But her son, not Mr. Allen, but her other son, Mr. Sullivan, who was the personal representative, was deposed. And he did indicate that his mother knew what she was doing, let's say. Whether she intentionally defrauded the bank, I don't think it got to that level. But did she intentionally give half of her property to her other son and intentionally execute the mortgage as if she owned the entire property? Yes, she did. And then there's the added layer of fraud that was not committed, obviously, by any of the lenders in this case, but the added layer of fraud where Ms. Sullivan was defrauded by this other fraudster who died in prison.
Yeah.
And based on all of that, I think this case was screaming for equity. And in fact, I would point out to the court that I believe my client could have imposed, tried to foreclose its mortgage on Ms. Sullivan's half of the property, and then asked for an equitable lien on Mr. Allen's half of the property. They chose not to do that, Your Honor, because of the situation with not only the gap between recordings, between the title search update, but also because of this other fraudster's fraud. It didn't feel right doing that. And so they made the conscious decision to just impose an equitable lien because that was fair. That actually put all of the parties in the same position they would have been in if this woman had never met that fraudster.
And it's interesting because if you look at the equitable subrogation, the whole purpose behind that, as I understand the case law, is to put people back, make them whole, make it a level playing field. And so based on that and under the circumstance, and this is kind of a really, it's factual, you have fraud, you have somebody who defrauds her, goes to prison and dies in prison. Then you've got her situation, what she has done. But the bottom line is legally under the case law. And Fishbein seems to be addressing a lot of the same issues in this case. Where did the court appropriately, under the circumstance of this case, granted an equitable lien under the circumstances, equitable subrogation lien?
And I believe, Your Honor, that the court did for the very reasons you're saying, because Ms. Sullivan, the principal amount of her mortgage that was outstanding, the one that she entered into without any fraud whatsoever, without any mistakes being made by any lender, and that was the exact amount of the equitable lien that Judge Little imposed in this case.
So basically, the reasoning behind all that, really someone should not get a windfall. Somebody should not benefit from that. So basically, not a penny more, not a penny less. It's just the amount.
We completely agree, Your Honor. Yes, and that's what I think happened absolutely in this case. I don't think it can be contested in terms of the amounts. So then, to me, the only focus then at that point is the prejudgment interest, perhaps, and the Rosansky decision that talks about whether or not we could actually foreclose this lien, because I think the case law firmly supports the fact that my client could impose the lien, but now can they foreclose it under Rosansky, which frankly did not come out when the final judgment came out in this case. It was a few months later. But under Rosansky even, I've read that case multiple times since it came out, and under Rosansky, I would say, Rosansky kept in mind that, as this court's already discussed, it's a court of equity. It's looking to do justice. It's looking to do what's fair. And so for that, you have to look at the totality of the circumstances. Each case is going to be different. In the Rosansky case, Mr. Rosansky, there was no doubt that Mr. Rosansky was not in default on his mortgage. He was defrauded by his ex-wife, and when the dust settled, he had no intention of stopping paying that mortgage, and he had no intention of defaulting and was never near default. That's a very different case than we have here, where maybe Ms. Sullivan did not, there's no evidence, and I want to make this clear, there's no evidence that Ms. Sullivan was defaulted on her original mortgage that was paid off. But Ms. Sullivan did, at some point, stop paying the new mortgage, which went into default, number one. And number two, she passed during the proceedings, so at that point it was inevitable that the loan was going to go into default. Whether it was the old loan or the new one, it was going to go into default. Number two, what's part of the record, or number three, what's part of the record is that Mr. Allen even executed an affidavit of indigency during this case and was set forth his income and his liabilities, and it's a zero balance according to the affidavit that he executed. And so he had no ability to pay either mortgage in this case, which I think is very important because the Rosansky case talked about, there's two cases that really give any guidance that I can find in the state of Florida. After an equitable subrogation lien is imposed, what do? Do you get prejudgment interest? Do you get to foreclose it right away? And aside from Fishbein and Tribeca, and Fishbein talks about foreclosing in dicta, and Tribeca talks about prejudgment interest in dicta because that issue was waived in the Tribeca case, so the court never reached it. But it seems to indicate in both cases that you can do both of those things. You can get prejudgment interest and you can foreclose it under the right circumstances. And our position here is that these were the right circumstances, that in fact there was no way either the loan that was paid off or my client's loan was going to get paid by either Ms. Sullivan or Mr. Allen in this case. And the Fishbein court did talk about the fact that, the Rosansky court talked about the fact that in Fishbein there were 3 prior mortgages that were paid off, and one of them, not that it was in default, I think the court used the word that it was in arrears or something, overdue. They used the term overdue. And that's really the only guidance that we have from Fishbein, that it was the underlying debt that the court was even focusing on. But I think equity focuses on the totality. Equity focuses on what's fair and what's just.
And there's case law, not necessarily under that realm, but in doing some research, it basically, there's cases to the fact that prejudgment interest is appropriate in equitable actions, and there's other cases involving other matters that basically indicate that as well. And so Fishbein, you're correct in your review of Fishbein as well as the other. And it's interesting, there's actually, I think there was even a case out of the 4th District Court that awarded prejudgment interest when you're dealing with equitable lien as well. I think, I'm pulling it up, diversified commercial developers. So there's case law supporting that proposition.
I agree, Your Honor, I believe so. And the one thing, before I sit down, that I will point out factually is that initially in this case, we had asked for prejudgment interest from the date that the loan was given. That was corrected later in the case before the summary judgment order and the final judgment was entered to reflect that prejudgment interest would only go from the default on the loan, because that's the fair point, I think, where the interest should start to accrue.
Just a minute, because I know he raised the issue of the list pendants. Take a minute and address that.
Oh, and the amendments of the list pendants.
Yes.
I believe that the amendment, first of all, relates back to the initial list pendants. Secondly, the only lien in this case that would be considered another lien that this court had to worry about, or Judge Little at the trial level had to worry about, was Mr. Reeder's lien for his attorney's fees. And that was imposed while this case was pending and while the list pendants had been recorded. So he clearly took his mortgage lien for payment of his attorney's fees subject to the outcome of this lawsuit. So I think the list pendants issue in this case is a bit of a red herring.
Very good.
I thank you for your time, and I believe that for those reasons that we've already discussed and that are further fleshed out in our brief, that the final judgment in this case, if it is determined to be a final judgment, be upheld. Thank you.
Thank you.
Thank you.
In rebuttal, I would just like to address the issue about the prejudgment interest. Yes, we have it so that they did it as of the day of the default. But again, with this diagram, the day of the default is several years later than the day that the figure that they're using was paid. So it doesn't account for all the payments that were made from the day of the closing to the day of default, where the principal would have been reduced. Again, in any other scenario, that is not an accurate figure of what was owed as of November 1, simply for that reason. They didn't take into account the principal reduction in payments made from the day of the closing to the day of default. And for that reason alone, this case needs to, this court should reverse on that basis. Thank you.
Okay, thank you.